Welcome, everyone. I'm Melissa Bird, Director of the American Museum of Tort Law. The American Museum of Tort Law is located in Winsted, Connecticut, and is dedicated to educating the public about tort law and its role in American society. The museum features exhibits, artifacts, and interactive displays that explore landmark tort cases and their impact on safety, justice, and corporate accountability in the United States. I want to thank you all for joining us today, May 1st, Law Day, which was established in 1958 by President Dwight D. Eisenhower. Law Day does provide us with an opportunity to help the public understand how law protects our freedoms. Today's discussion will be centered around the controversial loser pays model. Is loser pays another way to block access to the civil justice system? Let's find out. Our esteemed guests today are Joanne Doroshow, Executive Director of the Center for Justice and Democracy, Jeffrey B. Simon, National Award-winning trial attorney and Texas super lawyer turned author, and surprise guest Rick Newman, past Executive Director of the American Museum of Tort Law, past President of Connecticut Trial Lawyers Association, attorney and author. But before I hand over the reins to our guest speakers, I'd like to take this brief opportunity to encourage all who are watching to visit our website, which is www.tortmuseum.org, and take a virtual tour, as well as check out our online gift shop. It is stock full of iconic memorabilia, including stylish apparel designed by our interns, tote bags, and a fascinating library's worth of books, posters, and other literature, including Jeffrey B. Simon's new book, Last Rights, The Fight to Save the Seventh Amendment. Okay, it's my pleasure to introduce Rick Newman. Thank you so much for joining us today, Rick.
Thank you very much for having me. It's a pleasure being here. And I can't say seeing all of you, but I'm told that you're all here. Anyway, we are talking about this loser pays concept, and I want to sort of try to go back and put it into a little bit of context, and then Joanne and Jeffrey will take it from there. One, in my opinion, and I think in the opinion of a lot of scholars and historians, one of the linchpins of our system of American justice is the jury trial. It was one of the grounds for declaring our independence from England, that the king had taken away our right to jury trial. It's enshrined in the Constitution. It is foundational to our system of justice. Why? Why are juries so important? And I think the answer is because they are comprised of regular people. Justice is administered not by bureaucrats, not by professionals, not by legislators or governors. In jury cases, not even by the judge, although judges have a very important role to play. The wellspring of justice stems from juries, 12 regular citizens, or 6 in some jurisdictions, who gather and determine where the truth lies, who determine what justice is, who determine by their verdict the outcome of the case. It is critical. And most significantly, because these are regular people drawn from all walks of life, they can't be bought, they can't be bribed, they can't be controlled or corralled. Instead, they reflect the felt notions of justice under law within the given community in which they sit. Jury trials, I don't want to overstate it, are not perfect. But to quote Winston Churchill, who said this about democracy, democracy is the worst form of government except for all the others. Jury trials have stood the test of time as perhaps, and I think probably, the fairest way to achieve a just outcome, as reflected in societal values. And for exactly that reason, access to juries, jury trials are always and everywhere under attack. And we see this over and over and over again. Efforts to keep people out of court or to limit the reach and scope and power and authority of juries. For example, very often when someone buys a product, in the fine print is a clause requiring mandatory arbitration, locking the doors of the courthouse and forcing you to go off and arbitrate in a jurisdiction that you didn't select before arbitrators that you don't necessarily select either. It's a way of controlling and containing access to the jury. We also hear efforts to limit and undermine faith in the jury system. We hear horror stories. For years, we've been hearing horror stories about frivolous lawsuits. Never a word about frivolous defenses to lawsuit. Never any justification for these bogus claims. Never any mention that the system, the court system, already has in place methods of dealing with any lawsuits that are not meritorious. And yet this bugaboo keeps rearing its ugly head over and over. All of these are efforts to limit access to the courts and limit the scope and power and authority of juries. And so now, today, once again, we see rearing its ugly head this notion of loser pays. All of these attacks are presented as common sense. Who would want frivolous lawsuits? It stands to reason that we don't want frivolous lawsuits. Likewise, loser pays is presented as another panacea. This will put money back in the pockets, it is claimed, of regular American citizens. It will make people more careful about filing lawsuits because they don't want to lose. So the questions that we want to discuss today is, what is loser pays? How does it work? Is it a good idea? Who benefits from this sort of thing? And so what I want to do is talk about that for 1 second before turning it over to Joanne Doroshow and Jeffrey Simon, who know more about this subject than I do. One of the issues with loser pays is the idea that if you file a lawsuit and you lose, you have to pay the costs and sometimes the attorney's fees of the other side. This has been an idea that has been previously considered and rejected by the overwhelming number of courts and states and jurisdictions in this country. Why? Why has it been rejected? Because it has a chilling effect on access to courts. People, unlike insurance companies, unlike large corporations, are not in the business of paying out claims if they lose the case. Lawsuits are inherently unpredictable. Good cases can be lost, bad defenses can prevail sometimes. And so when you go to court, you take the risk that even though it's a good case, you could lose. And if you lose under the loser pay system, all of a sudden, the family, the plaintiff of the injured child, for example, may be on the hook and required to pay tens or hundreds of thousands of dollars to the defendant, the corporation that manufactured the defective product. Given that risk, that would serve to discourage people from filing lawsuits, even if they're meritorious claims. The risk may outweigh the perceived benefit. There's another reason why I think loser pays are bad ideas, and that is because lawsuits are inherently unpredictable, because now anyone can file a meritorious claim and you take your chances in court. Because of that unpredictability, it fosters settlement. Both sides are at risk with litigation as it currently stands. And because of that risk, in an effort to minimize the risk, it fosters settlement. In a situation where one person or one party, the family of the injured plaintiff, can't afford to pay if they lose the case, they're less inclined to file lawsuits. And for that reason, the defendant, the corporations in this hypothetical, would be less inclined to settle or less inclined to settle for a fairer figure. As a result, loser pays is an idea that will have a chilling effect on both access to courts and resolution of disputes. There are other reasons, there are cases, there are jurisdictions that have considered this. The system we have is called the American rule. Other jurisdictions, England, for instance, has what's called the English rule, which Joanne Dorshow can certainly talk about. I can go on about this at some length, but I will stop here and turn it over to our other panelists about this idea whose time has not and should not come. Thank you very much.
Thank you so much, Rick. And before I introduce Joanne, we are just going to play a commercial that came out relatively recently and see if Loser Pays is, what is actually happening across the current administration. Hannah?
Under Biden, Americans' cost of living skyrocketed. Food, housing, auto insurance. Lawsuit abuse is a big reason everything's more expensive today. Frivolous lawsuits cost working Americans over $4,000 a year in hidden taxes. President Trump understands the problem. That's why he supports Loser Pays legislation to stop lawsuit abuse and put thousands back in the pockets of hardworking Americans. It's time to make America affordable again. It's time to support the president's plan.
Okay, Joanne, after watching that, I'm very excited to introduce you. Thank you for being with us again. Joanne is the Executive Director for the Center for Justice and Democracy. Hi, Joanne.
Hi, how are you? How is everybody?
Oh, very well. And we're excited to be able to, share this information with our listeners.
Okay, so I'm Joanne Dorshow. I am the Executive Director of the Center for Justice and Democracy, which is a consumer rights oriented organization that works to protect the civil justice system. So let me just set the table a little bit after having seen this ad. For those who may be unfamiliar with where this issue fits into the larger discourse around what we call tort reform or tort restrictions, or Ralph Nader likes to call it tort deform, basically beginning in the 1970s and then really kicking into high gear in the 1980s and to the present day. Big economically powerful corporations have pushed for laws that make it more difficult for people to sue them when they injure or kill somebody. Because these laws interfere with the power of judges and juries, many states have found them unconstitutional. They are anti-victim, they're anti-consumer, they're anti-jury, and frankly, they're anti-99% of the US population. So with that in mind, let's talk about this loser pays idea. Or as I prefer to call it, many people prefer to call it the English rule or the British rule. Very simply, as Rick already described, it means the losing party in a case has to pay the other side's attorney's fees and costs. So in other words, you feel like you have a very strong case against a company like General Motors or somebody like Elon Musk, but they overwhelm you in court and you ultimately lose. You would have to pay all of their inflated hourly legal bills. So you don't have to think too hard about this concept to understand how that's going to chill your constitutional right to access the courts if you feel like you've been wronged in some way. It's already hard enough to bring a lawsuit, but now you add on top of that the risk of financial ruin if you were to sue a corporation, and obviously you're not going to bring that. You're going to think twice about bringing a case. Where did this idea come from? Well, came out of England. It was part of the common law there back in the 13th, 14th century when access to the courts were really reserved for the wealthy, the aristocracy. They didn't want poor people suing them, so they developed this rule. Post-Revolutionary War America, we decided not to bring this rule over to the United States. We wanted each party to be able to bear their own costs in a lawsuit, and this would make it so ordinary people could afford to access the courts. Only one state right now has the English rule, and that's Alaska. And the law was already on the books when Alaska was a territory back around 1900. And then when Alaska became a US state in 1959, it was brought in and codified into Alaska rule. But that rule is a little different, applies to all civil cases. There are many exceptions to it, and judges have a lot of discretion to reject it. But otherwise, I've seen state after state reject it when it's come up in lobbying conversations, including insurance lobbyists. They all hate it. It was part of the law in Florida in the 1980s, but it was the Florida Medical Association that got it repealed there because they hated it so much. I remember in 2013 when Mike Pence was governor of Indiana, he withdrew support for loser pays or the English rule because there was such strong opposition in Indiana by state lawmakers there. Victor Schwartz, who's general counsel of the American Tort Reform Association, testified against it in Congress. For those old enough to remember the contract with America, Newt Gingrich's policies in the 1990s, loser pays was part of that. And then they ended up proposing an extremely diluted version of loser pays back then, and even that did not pass. So we're having to talk about this again. Two main reasons. One, you just saw. This ad started to run. If you live in the Washington, D.C. area or in some selected states, you may have seen this ad running on TV or in social media platforms. Suddenly we need to pass loser pays in this country. It's a campaign that is being run by a Trump group called Make America Affordable Again, which has some indirect connections to Elon Musk, and a group that he has called Building America's Future, or it's a group that he's somewhat involved with. Someone got the bright idea that people could be convinced that lawsuits were the cause of skyrocketing consumer prices or the cause of the country's, Trump-created economic crises. So the ad tells people to call Congress, even though there is no legislation in Congress on this. Now we know that Elon Musk, for example, does not like to be sued. We're about to put out a new report, our organization, on electric vehicles. And Tesla is being sued all the time, and they're settling a lot of lawsuits. Most of them have to do with their autonomous vehicle technology. But we know that this is an issue that he would probably care about. But, what about Trump himself? Is this something he really cares about? Well, maybe, kinda. In January, he had an event on the California wildfires, and he was asked about this. And he basically said he loves loser pays. And I will, here is his direct quote. You could cut your courts in you could cut them down about 90%, loser pays. You know what would also benefit medical? If you had loser pays for medical, your medical costs would go down 50%. That's an interesting thing, end quote. Perhaps he needs to consult with the Florida Medical Association that got rid of this law in the 80s because they hated it so much. But let's discuss this a little bit. So the ad, they claim that if you pass the English rule, you'd save Americans $4,200 a year. It's a lawsuit tax. They call it or a frivolous lawsuit tax. So let's take that number apart. First, to be clear, loser pays, like any other tort restriction or tort reform, has nothing whatsoever to do with frivolous lawsuits. These laws apply no matter how much merit a case has, No matter the extent of misconduct or the severity of someone's injury, they hurt the most catastrophically injured people. Second, frivolous lawsuits, despite what the propaganda machines like this might try to tell you, are not a problem in the United States. That's because, unlike corporate lawyers who are paid hourly fees, and no matter what they do, trial lawyers, plaintiffs' lawyers are paid on contingency. That means they're only paid if they're successful, and then the judgment comes out, or the fee comes out of the judgment or settlement. Therefore, attorneys paid on contingency are extremely selective about the cases that they bring, because they'd be out of business if they were bringing frivolous lawsuits. They'd never get paid. In fact, many conservatives have written about how the system screens out baseless lawsuits. Plus, the system already has other checks and balances already in place. Judges will throw out a frivolous lawsuit, and they could sanction the attorney who brings them. So it's just a non-issue. So back to the ad that we saw. They throw around this lawsuit tax number, $4,200 a year, that would end up in everybody's pocket if they enacted the English rule. So let's talk about how absurd that is, starting with how they calculate that number. That was a number that was concocted by the Institute for Legal Reform, which is the tort reform branch of the U.S. Chamber of Commerce, which is the second largest business lobby group in the country. If you read the report, you will find that they don't look at anything remotely connected to the legal system, jury verdicts, settlements, even the court costs in running the courts. Nothing connected to the legal system to arrive at that number. Instead, they base it on insurance premiums, the premiums that insurance companies force you to pay. Now, do you know what makes up insurance premiums? It includes the administrative costs of operating the bloated and incredibly inefficient insurance industry. We're talking about multi-million-dollar executive salaries, bonuses, jet planes, their advertising. It includes their profits, which last year surpassed $100 billion. It also includes things like auto fender benders, where no lawyers are hired and the cases don't come close to going to court. And so not only do these numbers, that number 4,200, have nothing to do with frivolous lawsuits, they have nothing to do with the legal system at all. But then you might ask, okay, well, wouldn't insurance premiums go down if they, limited lawsuits, maybe even legitimate lawsuits? Well, the answer is no. We now have 5 decades of evidence that shows that this never happened. When you weaken legal rights, the insurance company's costs may go down, but they don't pass that money on to policyholders. They pocket that money. That money stays with them, or sometimes ends up as dividends to their shareholders. The second reason why we have to talk about this now is because loser pays proposals have mutated into something very dangerous that the business community does support. It's basically one-sided loser pays. Pertains only to the victim. Only they have to pay the other side's costs if they lose. And in fact, there's a bill now being considered in Louisiana that would do this. It's SB 148. And there are other fee-shifting proposals that are popping up here and there, again, that only penalize the victim, never the defense or the insurance company. So it's a very dangerous development. Finally, I just want to make one other note that loser pays often gets conflated with a similar but also very problematic fee-shifting proposal in the context of what are called offer of settlement statutes or offer of judgment laws. These basically allow a wrongdoer, after a suit's been filed, the wrongdoer approaches the victim or say the family of an injured child and makes them an offer to settle the case. before the victim has, or the family has any idea what kind of damages, what kind of compensation they're going to need to provide care. The victims may be unrepresented by counsel when they're approached. And then if the family rejects the offer, sues, and then either loses or gets a verdict that's less than what the offer was, they have to pay the other side's fees and attorney's fees and costs. So while it doesn't technically chill your right to go to court, it does pressure victims to accept lowball settlement offers from insurance companies. So it's another way to tilt the legal playing field against the victim. So with that, I will stop there just to note that we do have a website where you can find more information about this, centerjd.org, CENTERJD.org, and we have a backgrounder on this concept of the British rule or loser pays. Thanks for listening.
Thanks so much, Joanne. Does anybody have any of our panel have any questions for Joanne before we move on?
I do. What is the rationale behind this Louisiana law? Why?
To stop frivolous lawsuits. It's the same circular argument that we've heard, but the fact is there aren't frivolous lawsuits, but they basically want to stop legitimate lawsuits is really what really what the impact would be. They want to keep people from suing.
Yeah, unbelievable. Do you think any evaluation of the likelihood of it passing?
I mean, it's all politics. So, hopefully people, if anybody is down there, they let their lawmakers or reps know that they don't like this bill.
Yeah. Good. All right. Well, thank you very much. Appreciate it.
I want to welcome Jeffrey B. Simon. He's a leading litigator. He is a negotiator and a commentator and the founding partner of Simon, Greenstone, and Pantier. Welcome, Jeffrey.
Thank you for having me. Loser pay provisions are a regressive tax that is intended to deter and punish claimants who look to hold powerful corporations accountable for wrongdoing. A case in point, on July 20th of 2012, James Holmes carried out a mass murder at a movie theater in Aurora, Colorado. He shot 12 people to death and he injured 58 others. One of those he killed was Jessica Gawi, an aspiring sports journalist who was in her 20s. In preparation to commit this slaughter, he purchased over 4,000 rounds of ammunition and high-capacity magazines from online weapons dealers. In 2014, Jessica's parents, Sandy and Lonnie Phillips, filed a lawsuit against those online ammunition retailers. They asserted theories of negligence and public nuisance, and they alleged that the defendants engaged in unreasonably dangerous sales practices by not having safeguards against that kind of high volume acquisition by somebody who had a history that would suggest shouldn't have that kind of arsenal. But the following year, in March of 2015, a U.S. District Court in Colorado dismissed the case, finding that the defendants had complete tort immunity, both under federal law and prevailing Colorado state law relating to gun and ammunition sales. Adding insult to deep heartache, he chastised the Phillips for attempting to, quote, destroy legitimate businesses. And then, pursuant to the state immunity laws, which had a loser pays provision, he ordered the Phillips to pay the defendants legal fees of over $200,000. The largest of those fee awards was to an ammunition dealer, Lucky Gunner, in an amount exceeding $111,000. Now, the company apparently didn't need to recoup the legal fees in order to survive. In fact, they pledged to donate the money to gun lobbies and gun advocacy groups. And they reportedly set up a website where people could vote on how to distribute the Phillips's money to these various gun lobbies. As you might imagine, the impact on the Phillips was quite different. The economic burden was overwhelming for them. They had to file for bankruptcy and they lost everything. But they didn't stop fighting. And in 2023 in Colorado, they led the charge successfully to repeal those state gun industry immunity laws, including the loser pays provision. In fact, the law was named Jesse's Law after their daughter. And I think what that case demonstrates is that the American rule, where each side pays its own way, irrespective of outcome, unless there's a judgment, of course, is consistent with the best ideals of political progressivism and conservatism, and I would argue fundamental decency. And that if we change that system to again favor powerful industries over people who are legitimately seeking legal remedy, irrespective of whether they win or not, then, as Rick pointed out, we are again just repealing the Seventh Amendment, piece by piece, and we'll all be the loser. Thanks.
Thank you, Jeffrey. Rick or Joanne, does anybody have any remarks for Jeffrey before we open it up to our viewers?
No, I don't have any questions. I think that we have sort of covered this. It seems, in fact, I'd like to hear from the people who are watching this, because it seems almost self-evident to me, and I think if I could speak for Joanne and Jeffrey, that this really is a cynical, cold-blooded effort to limit access to juries, to reduce the rights of injured people to get justice. I can't see it any other way. As Joanne was pointing out, there's no link between the figures thrown out in this commercial, $4,200 a year, and any kind of reality. There's just no savings, except for the pockets of the big corporations who are hoping by this method that they'll be sued less. So I don't have questions, but I would like to hear from people in our listening audience about whether, are we missing anything, or is it as self-evident as I really think it is? Are there questions coming in?
Joseph asked, what's the difference between loser pays and liability for bringing a frivolous lawsuit?
Well, liability for a frivolous lawsuit is more or less possible sanctions, I'm guessing, is what we're talking about. Whereas a loser pays, most people that bring lawsuits and lose are not, I mean, the overwhelming majority, they're not filing a frivolous lawsuit. It's just that sometimes you lose. Somebody has to lose in a case. These cases are not frivolous. They don't survive early motions from the judge to dismiss the case. They don't survive getting in through the trial and judgment if they're frivolous. So they're not frivolous. But if they lose, then they have to pay the other side's attorney's fees and costs. So it's like sanctioning them just for losing the case, as opposed to having anything to do with bringing a frivolous lawsuit. So anybody else have something to add to that?
Well, I think that's
Yeah,
right. Thinking about the gun case, right? Allegations included the proposition that an exception to the immunity rule had been met, that the immunity law was unconstitutional. those are good faith challenges. They just didn't happen to prevail. The judge disagreed with them. And yet, in addition to losing their daughter, that economically they were destroyed for simply having had the temerity to try to accomplish those laudable goals. They were obviously laudable, resulted eventually in a repeal of those very laws by the Colorado legislature. So there was nothing frivolous about the case, and yet they were punished like it was.
Another aspect that I just want to touch on is that frivolous cases are often, nearly always, screened out by the lawyer. Because, as Joanne pointed out, lawyers only get paid if they either win the trial or settle the case. And a case without merit is not a good investment of the attorney's time. When I was practicing, we would get inquiries from people, serious people with serious inquiries, but very often they just didn't have a case. And it was our job to say, this is not a case that I'm willing to take on. Now, maybe they could find some other lawyer, but that lawyer will also struggle to stay in business if he or she continues taking cases that are not going to result in a settlement. So the first bar to frivolous lawsuits is they don't get brought by lawyers. And then judges can entertain motions for directed verdict or to dismiss the case because they have no merit. And that's why this frivolous lawsuit thing, that's one reason why the frivolous lawsuit argument is a red herring. And the second is very often, I don't know who's responsible for it, but cases that are won by the plaintiff are later spun by the defense as this was an outrageous miscarriage of justice. This was a frivolous lawsuit. It never should have gone to court. And yet, a jury has heard the evidence. The judge has ruled on what's admissible or inadmissible. The judge has instructed the jury on the law, and the jury has returned a verdict. Almost ipso facto, to lapse into Latin, it was not a frivolous case. So these ex post facto examples that are tossed around, look at how crazy the system is. These are frivolous cases. Very often on real examination, turn out not to be frivolous. So the consumers need to be aware of these arguments that seem to be so reasonable and so commonsensical. Who wouldn't want to save $4,200 a year? Who doesn't want to get rid of all of these frivolous lawsuits? It sounds so good and so common sense and so reasonable, but it's not. It's really deceptive and misleading and calculated to weaken our access to get in front of juries and to let juries do the job of administering justice. It's the end of this sermon for today.
Does each state have their own version of pay to lose rules?
Most states don't have this rule at all, so you wouldn't find it anywhere on the books. The state that I mentioned, Alaska, that has had this on the books for a long time. If you go to it's called Rule 82, and you see it sort of lays out very specifically the percentages that the other side has to pay, with the percentage out of a judgment that a losing defendant would have to pay. Texas has a limited, more diluted version of loser pays. It passed in 2011, I believe, where you can find some language there that has had a negative impact on some people. We talk about one case in our backgrounder, a woman who was catastrophically injured as a result of medical malpractice. And she had a very hard time finding an attorney down there because so many of the laws that have passed in Texas are very anti-patient. It makes it hard to get somebody, but they did bring a lawyer in. They found somebody, but there were such strict rules as to technical rules about finding an expert and so forth. They couldn't meet these ridiculous deadlines and ultimately had to pay the other sides, or were charged with the defendant's attorney's fees and costs. very unfair. I mean, she was destitute and ultimately passed away. So it's a good example of another good example of how this can really harm somebody, an innocent person. But most states don't mention it at all because it's not part of their law.
One of the, I guess, major characteristics of Donald Trump is that he tends to frame things very effectively to advance his agenda. I would like some possible ideas from the panel on a new frame in opposition to the commercial that we watched, not based on efficiency and cost savings, but something that would motivate people equally from an emotional and an intellectual basis to pressure their legislators to change the loser pays laws in their state and perhaps nationally.
Anton, that's a prescient point. That 4,200 number that Joanne took apart, it doesn't come from left field. It's also the number that economists have determined each American will pay as a result of Trump tariffs. It's literally the same number, 4,200. So that number came from somewhere. It's just not germane to the issue. It was simply flipped politically, I would argue, or either that or it's a heck of a coincidence. But I would also make the point that what if a person who ran for elected office lost, had to pay the other side's campaign fees, right? I mean, you ran a frivolous campaign, you lost, right? That sounds awful. Everybody running for office would think that's a terrible idea, except I guess incumbents who know they're always going to win, right? It is profoundly unfair. In addition, in terms of the number itself, being completely baseless and a whole lot like another number that's being politically spun.
Good comparison.
Yeah, I mean, and we find that the best arguments are when you don't talk about loser pays as a concept because it sounds somewhat good to people. Yeah, somebody who loses should pay. Put it in the context of if you are somebody who needs to sue Elon Musk for something or pick another huge corporation and you happen to lose, you would have to pay all of their inflated hourly legal bills. These lawyers get paid $1,000 an hour. As soon as you put it in that context, people do not support it. And also, honestly, with regard to the whole purpose of this ad is this was started before the tariffs even. And it was clearly an attempt to try to change the subject or the fault of why inflation was happening or consumer prices were going up and blaming lawsuits for that. Nobody in their right mind thinks that now, since the tariffs, that lawsuits are the reason why consumer prices are up. So I don't think they even think this makes any sense anymore, honestly. And I think that's maybe why this never, and so far has not developed into any kind of federal legislation. Even though the ad tells people to call Congress, I think they know it's ridiculous. So,
about contingent fees, why we have them. Look, Rick and Joanne don't age, but I do. And I've been practicing law for 32 years. And in that amount of time, I've learned how to do some things effectively. And if somebody is terribly injured as a result of the misconduct or malfeasance of another, and they want to hire me with my experience trying cases of 32 years, and I were to charge them an hourly rate, very few people can afford to just pay that hourly rate, unlike a big corporation that hires a big corporate law firm to do work for them. And so the whole point of the contingent fee is to give them access to the courthouse where I take the financial risk that if we don't win or settle, I get nothing. Otherwise, most people who are terribly injured would never get the opportunity to hold the company or industry or person that they legitimately believe harmed them accountable. And so the whole idea that in the event they lose, they should have to pay the other side's inflated legal fees, as Joanne put it appropriately, is equally as unfair and illogical.
Noah asks, what do you think about the alternative argument that fewer lawsuits mean fewer safety protections for everyone, not just compensation for victims? When companies decide whether or not to add a safety feature or improve a defect, they are explicitly calculating the cost of the improvements versus the anticipated costs of litigation. So the cost, quote unquote, savings of loser pays disincentivizes companies from improving safety and innovation.
100%. That's an excellent question. Lawsuits protect us all, whether or not we go to court. That's because of the very strong deterrence function that the threat or fear of lawsuits serves. Products are safer, cars are safer, the environment is better as a result of the fear of lawsuits. And when you stop legitimate lawsuits, the costs to the economy are huge. Just imagine, more injuries, healthcare costs go up. When you limit lawsuits and stop people from being compensated, those injuries don't disappear. It's just that the wrongdoer is no longer responsible. So who's paying? Well, people who are catastrophically injured, people who no longer get compensated from the wrongdoer, may have to turn to government-funded health and disability programs, Medicaid. We know of many victims who are in states that have been blocked from suing as a result of tort reform laws that have had to go on to Medicaid, or their children, a catastrophically injured child who needs a lifetime of care is going to have to get that care somewhere, and they're going to have to turn to taxpayers through Medicaid for it. So the cost to the system of blocking legitimate lawsuits is enormous, both in terms of making us less safe and having to have taxpayers and others compensate for the injuries.
Is there any evidence from the UK, which has loser pays, on the impact of loser pays on tort lawsuits, injured people's lawsuits, death lawsuits? And second is to the trial lawyers on the panel, of all that, you have a big filter system. You don't want to bring a case that loses. So all the cases you've brought in, how many have you actually lost? That is, not settled, not jury verdict, but actually lost at trial. And how would that have impacted your clients? I'm assuming that's just a very small percentage.
Should I take the first one?
Yeah, and I'll address the second, maybe Rick as well. Yeah.
About the UK. First thing I will say is the United States has, with all its flaws, we really do have the strongest, best civil justice system in the world. We're the only country in the world, including compared to the UK, where the civil jury has a large say in how justice is administered. They don't really have that anywhere else in the world. In the UK, insurance, legal expense insurance is very common. So they have a loser pays system, but if you have the money to buy insurance to cover those costs, that insurance is readily available to you. It's sold, I think, as part of homeowners policies and other policies, or you can get it on an individual case-by-case basis. It doesn't really exist in this country. So if you can afford the insurance, you can get protected in the UK. And so it doesn't have that kind of ruinous, devastating impact it would have on plaintiffs here in the United States.
Jeff,
Go ahead, Rick.
No, you take it away.
I was just going to say, it's a good question. Obviously, case selection is a very important part of a successful plaintiff's practice that's built on a contingent fee model. Having said that, the very best trial lawyers in America lose cases sometimes. Not just because some cases are hard, but because they took the risk with their client. They believed in a case that was not a sure thing, even though it was a good case. Now, on the whole, in a good practice, most of the cases are successful in some way. They achieve an objective either through trial or settlement that the client is satisfied with. But as I say, you need a system that doesn't deter taking risks, especially for big things that really matter that aren't sure things. And a loser pays system would absolutely chill that.
I absolutely agree. My firm years ago took a case with the express purpose of trying to change what we considered to be a bad and unfair and unjust law. And our analysis was, we will lose this at the trial level. We will appeal to a higher court. We're prepared to go to the Supreme Court if we need to, but this law needs to be changed. And we lost at the trial court. We appealed to the higher court, the appellate court, lost there. We petitioned to the Supreme Court and they turned down our appeal. A year and a half later, a case very, very, very similar arose in Pennsylvania. They lost at the trial court. They appealed to the appellate court. They lost to the appellate court. They petitioned to the Supreme Court. The Supreme Court took the case and overturned the law. So we were a year and a half early or whatever. Had this loser pays law been in effect, the family simply couldn't have afforded to take the case. We took the risk. We got no fee out of the case. The family got no compensation, but at least they were not obligated to pay a giant multinational corporation hundreds of thousands of dollars following the death of their son. So you take the risk and you try to change things for justice when you need to.
I'm a professor at a law school and teach tort law and remedies, and so and law and economics, and so I grapple with these questions. And it seems to me that a loser pay rule can be very helpful to a successful plaintiff, because right now, if my client has $800,000 in medical bills he can't pay, and sues for those and wins every one of those $800,000. He still declares bankruptcy because after his attorney takes the contingency fee, he still is burdened with a crushing amount of medical debt he can't begin to pay. But under a loser pays rule, the losing defendant would have to pay his attorney's fees and he'd be able to keep his compensatory damages. And it does seem a little ridiculous to me that we go to tremendous lengths to tabulate to the penny the compensatory damages that a plaintiff is entitled to when the attorney is going to take a big chunk out of that, and the plaintiff is going to be the successful plaintiff, the worthy plaintiff, with the meritorious case is going to be woefully undercompensated because they can't get their attorney's fees out of the defendant.
In the example you provide, if it's a good case, you know, there are options within the case. I mean, one would be, I'm not going to resolve the case unless you agree to pay X amount in attorney's fees. That's one. But that's by negotiation. That's not compulsory. Number two, if the conduct obviously is egregious and the harm is substantial, then of course, in addition to medical bills, presumably there will be opportunities for recompense for, you know, physical harm and mental anguish and punitive damages and so forth, which in no way, shape, or form is meant to suggest that the example you provide is not provocative. It is. It's just that with any good idea, there is always the susceptibility of mischief and abuse. And I promise you that loser pays is intended to benefit industries, to deter and to punish claimants who legitimately pursue legal rights. And if that weren't true, they wouldn't be advocating for it so strenuously.
Agreed.
Excellent. thank you for all the questions, everyone. They, there's obviously a lot of interest with the topic because I see that there were even more questions. I want to thank our distinguished guests for appearing today. We appreciate at the museum being able to offer this type of information to the public who are thirsty for this type of insight into our justice system, especially with our current national narrative. I also want to thank everyone for tuning into this thought-provoking dialogue. It is crucial that we understand that the presence of a robust legal framework strengthens our democracy and it protects all of us. Again, please visit www.tortmuseum.org. If you happen to be in the northwest corner of Connecticut, we would love it if you'd stop by the museum in person. And I hope everyone has a great week. Thank you again.